IVM.
What turns you on? For some, it's a sexy voice, or maybe swimming naked in the sea. For others, it could be just a great conversation. It's so varied, isn't it? Which is what makes it harder to talk about the concepts we are discussing today. Obscenity, decency, and morality, and how our constitutional rights are shaped by these vague words. Hi, I'm Priya Mirza, and I teach political science at Zakir Hussain Delhi College, University of Delhi. And giving lectures is what I love to do. You can ask my students. But this is not a lecture on the Constitution, but really about how the Constitution shapes what we say, how we say it, where we say it, and who we say it to. And on what grounds can we be stopped from doing that? We are kickstarting today's discussion on obscenity by talking about Boris Becker, the tennis world number one at one point and often considered one of the greatest tennis players ever. But we aren't concerned with that. We are concerned with the year 1994 when Boris Becker appeared on the cover of a magazine called Stone, naked with his black girlfriend, Barbara Feltus. In the photograph, his hands covered her breasts. But this wasn't Playboy or a photograph that was designed to arouse. The point that the German and very blonde Boris Becker and his black girlfriend were making was about racism and ending discrimination against blacks. This was reproduced in Sports World, a magazine published in India, and the photograph went alongside the caption. Posing nude, dropping out of tournaments, battling racism in Germany. Boris Becker explains his recent approach to life. Boris Becker unmasked. Fine. And then Anand Bazar Patrika, a newspaper in Kolkata, also published the photographs along with the article. And that's a minor detail, which is hugely important. But this made a lawyer at the Calcutta High Court very unhappy. He filed a complaint under Section 292 of the Indian Penal Code, arguing that this would corrupt young minds, both children and youth of this country. That's pretty serious. But who's to be accused here? Boris Becker or the publishers? Going by the law, it's the publishers of the magazine who were charged for corrupting children, youth, and womanhood. Whoa, that's a lot. Did this case stand a chance of winning? Going by the history of Section 292, it did. The Indian Penal Code was codified by 1860 by our good friend Macaulay, who never married and had several views and opinions on sex and vulgarity. But that was the 18th century. The morality of many of our laws comes from British men who codified these laws more than 100 years ago. Now, Section 292 of the Indian Penal Code 1860 deals with obscenity. It imposes criminal liability for the production, sale, and distribution of obscene material. And this material could be anything: a book, a pamphlet, paper, writing, drawings, painting, representations, practically everything. And this law states that these materials are obscene. If they are, and now I'm going to throw two Victorian age words at you, lascivious or prurient. Lascivious means feeling or having an overt sexual desire. And you and I would have a simpler word for it. It's just called being turned on. And prurient means having an interest in sexual matters. But what's wrong with that? According to the colonial British, these feelings tend to deprave and corrupt a person. But you would have noticed that the word obscenity was not defined. This was a very Victorian age idea where being sexually turned on was often seen as having a dangerous state of mind, that sexually aroused people were mentally unstable. But what does sexy mean anyway? A fully clothed man could be very sexy, while a nude woman maybe not. But that's how I see things. And it's such a personal, private affair, isn't it? But the colonial Indian state did not want to leave anything up to interpretation or imagination. But the question is, how does one prosecute for being obscene if there's no definition of obscenity? Now, this came up in the Hicklin case, and this was a case in England in 1868. The Hicklin test was that if a few words, that's right, just a few words, are obscene in an entire book, the book would have to be banned. And this Hicklin test was formulated by the British judge, Alexander James Edmund Cockburn. That's his name, Cockburn, not making it up. So a man named Cockburn said that even if a few words are obscene, the entire book would have to be banned. And in a few cases, the joke was on the British. Ismat Chughtai and Saadat Hasan Manto, two of the greatest writers of the 20th century, in 1946 were both charged with Section 292 of the IPC. But the prosecution was unsuccessful because the alleged lewd views in their books were so undefined that the prosecution could not demonstrate that their books were obscene. And others were not so lucky. In 1964, this test was used against a bookstall owner, Ranjit Udeshi. He owned a bookstall in Bombay and sold scores of books, one of them being D.H. Lawrence's book, Lady Chatterley's Lover. And he was prosecuted for selling obscene material. And the case came up in court. The Supreme Court, which struck down his fundamental right to expression to sell a book because it had a few paragraphs which could deprave and corrupt moral order. So the questionable idea that the court followed is that people who'd read this book, Lady Chatterley's Lover, written way back in 1929, get so aroused that they would become a threat to public order, morality, and decency. That's a lot. And here's the thing. When India drafted her own constitution, this was granted to us in the form of Article 19, the fundamental right, under which we have the right to express and receive information as long as this is not affecting public order, morality, and decency. But the court failed. It failed to demonstrate how reading that book would actually affect public morality. And the whole point about constitutional morality and Article 19 is the freedom to break away from what everyone thinks, that majoritarian views can be oppressive, and everyone has the right and the space to do what they like, watch what they like, even though it may be what the world considers wrong or indecent. But let's get back to Boris Becker, who by posing with his dark-skinned girlfriend was making a case about condemning apartheid, about racism, and talking about inter-race love and sex. So far from being racy, the intention was not to talk about sex, but racism. The court in this case thankfully saw the context. Unlike the Hicklin test, the court ruled that the context was important. It was not just the photograph which counted, but the accompanying text as well. The case, Avik Sarkar versus State of West Bengal 2014, said bye-bye to the Hicklin test. But we still have a long way to go in battling with the state's control over what we should be reading and watching. Governments do have a responsibility to prevent citizens from harming themselves and others. But there are limits to it. Yes, smoking is terrible, but let us make that choice for ourselves. We aren't babies. So smoking in public is banned, but not if I'm smoking in my bathroom or balcony. And the rules of pornography, a book or a video should be the same. But that's for the next episode. We will talk about the slippery nature of pornography and the constitutionality of laws regulating it. The longest constitution is for everyone. So share it with your friends and family, and I'm sure they will find this podcast interesting. But for now, this is me, Priya Mirza, signing off.